My name is Nima Shirali. We're here today with Mr. Jay Chauhan at his law office in Richmond Hill. Mr. Chauhan has over 40 years of experience practicing law in Ontario, and he's served as a deputy judge for 24 years at the Superior Court of Justice in Ontario. We're going to be hosting a CPD seminar series this year in July 2017, and one of the topics will be conducting a trial. I'm just going to ask Mr. Chauhan several questions with regard to what will be contained in that seminar. Mr. Chauhan, firstly, how do you get notified of a trial, and how do you make sure that you don't miss this important date?
Thank you for the introduction. I just want to tell the listeners that this is just a summary of what we're going to do for some programs that we will get the approval of for CPD purposes, so that you have your hours logged in there. But we'll be doing these things for that purpose, and each of the seminars will be 1 or 2 or 3 hours actually. But some of the topics that we'll cover today includes, firstly, as you asked me, how do you get notified of the date of the hearing? There is the date of the hearing is set by the court office based on their schedule. So it comes to you, and the most important thing actually, the lawyers and paralegals are used to the idea of looking at the date and putting it in their calendars. But if you're not a lawyer or a paralegal and not used to using a diary, there are occasions when people have missed out the dates. So it is very important, if you are a citizen and what is called a self-represented litigant, that you have a system of keeping that piece of paper right somewhere in your bedroom or living room where you know that you have to go for a trial. But well before the trial date, there will be lots that you have to prepare.
Excellent. And in terms of preparing, speaking of that, what's a good way to prepare the notes for the trial?
In this seminar, we'll address the question of how to prepare for the trial, both for a lawyer, a paralegal, or what is called a self-represented litigant. So how should you prepare is something that we'll be discussing in the seminar, and that will include preparing the trial notes, an opening statement, the background of the story, the way you present it to the court. How would you ask questions to your own witnesses so that you bring out your story, and then your list of questions that you'll be asking to the opponent witnesses, which is called cross-examination, and then of course your summary based on what you heard, and how will you present that evidence to the judge and explain to him that you've been able to bring out those issues of law and fact. And we will in this video try to prepare you, whether you're a paralegal, lawyer, or even a person that is conducting your own trial, and explain what you should do to prepare your notes so that you're thoroughly prepared and not just walk into the courtroom and say, I'm here, and the judge has to tell you what to do. It's not a good idea, because more prepared you are, the better you are in terms of winning your case.
I see. And is there any particular courtroom manners or courtroom behavior that we must observe?
Good question, Nima. What has happened in my observation, in all these seminars, I've attended lots of them, there's never been a seminar to my knowledge on direct question of what are courtroom manners. In watching the courtroom as a deputy judge for almost 24 years, that I watched the manners, and I just want to bring it to your attention as an audience, that I've been a lawyer in all the bar in England, India, and here in Ontario. And each country has a different courtroom culture. And wherever you are, and this seminar will be based on the culture of the Canadian courtroom in Ontario. But some of the rules will apply of behavior in other countries, which are Commonwealth countries in particular. And what do you do to stand up? Where do you sit in the courtroom? How do you address the judge? How do you look at the judge? When do you look at the witness? And how do you address your opponent? In England, you would say, my learned friend. Here is the opposing counsel. And if he's a paralegal, and I remember the question arising very often, do you call him counsel or do you call him paralegal? These questions arise. So in this seminar, we will be trying to address those questions, and more familiar you are, more comfortable you will be in the courtroom to make your point to win the case.
Excellent. And what is the sequence for the trial that takes place in terms of presenting the evidence, opening statement, presenting the exhibits and so on?
The trial is got a very carefully procedural system in which you have an opening statement, the lawyer stands up and makes a statement, the defendant lawyer then stands up and makes a statement, his position. You have the witnesses of the plaintiff who are first presenting their evidence, cross-examined by the opponent, then the defendant witnesses, and then the cross-examination by the lawyer of the plaintiff, and then your summary, and then wait for the judge to make an announcement. Sometimes the judge will say, I want to write a written judgment, we'll close the trial, and very often in small claims court, there'll be an oral judgment. That's the sequence.
I see. And in terms of the judgment, how are the closing arguments presented, and is there a good way to present closing arguments? Is there only one way to do that?
Well, I think, I think once you become skilled in trying to do the closing argument, you can prepare your notes because you know that you have an opening statement in which you made the comment as to what you will be presenting in terms of the law and the evidence. But at the time of the closing statement, what you want to observe is to emphasize to the judge that what you heard as evidence and how you would interpret that evidence and clarify that from your point of view is very critical, because you're helping the court in terms of the analysis of the law and the facts, and then presenting to the judge your position and asking the judge to take your position, and hopefully you'll get the judgment in your favor.
Excellent. This is a very interesting program that we'll be hosting this month and this year. If you can just tell our audience where and how the program will be done, will be held so that they may register.
We'll be doing a number of programs which will be aimed at both the lawyers and the paralegals, and even sometimes people who represent themselves in the courtroom, because there is statistics in the family law, for example. There's a huge proportion of the litigants who never get the opportunity to have a lawyer, and in the small claims court, a fair number of people go on their own to the court. And the number of people in higher courts also appearing are increasing, in which the clients are appearing on their own. So I think it is very important that you know how to deal with it, and we're presenting this to the seminars at the location called the onecenter.ca. It'll be also on my website, www.jchauhan.com. We also have a Facebook presence under the name of Angel Mentorship Group, and all these places will show where the seminars are, and we'll be emailing, and those interested should keep in touch at the Angel Mentorship Group, and then you'll know when the seminar is.
Excellent. Mr. Chauhan, thank you very much for your time today.
Thank you.